My name is Natalie Knott. I'm a supervising attorney with the Legal Aid Foundation of Los Angeles. And today I'm here to present a presentation on tenants' rights after the disaster to help the residents of the areas most recently affected by the fires in Los Angeles County access resources to help you rebuild your lives. We at Stay House LA and Legal Aid Foundation of Los Angeles are so sorry for your loss, and we want to be here to support you in rebuilding your lives in any way we can. Next slide. In this presentation, our objectives here are to help you understand your rights as a tenant if you are affected by the January 2025 wildfires, and where to turn for help if you believe your rights as a tenant have been violated. There are many rent stabilization ordinances throughout the affected areas that provide additional rights and protections for you, as well as we want to make sure you know about your federal rights, your federal benefits that you may be able to access. In the agenda for this presentation, we will recover your rights as a tenant if your home was completely destroyed, your rights as a tenant if your home was damaged but repairable, and any post disaster legal protections you may have if you are in unincorporated Los Angeles County, the City of Pasadena, or the City of Los Angeles. This section will be on tenants' rights in completely destroyed homes. And again, I want to say we are so sorry for your loss. But at this time, if you are a tenant whose rental home was fully destroyed due to the wildfire disaster, um, your tenancy or your rental agreement, regardless if it was oral, month to month, or a year or more, it ended the day you evacuated your home if your home was completely destroyed. You do not owe rent going forward. Your tenancy agreement has ended. Under state law, your landlord must return the unused portion of January's rent. So if you paid rent on January 1st and you evacuated on January 8th, your landlord must return the prorated amount from January 8th or January 9th through the end of the month, the 31st. And again, you do not owe rent going forward. Additionally, if your security deposit must be returned to you within 3 weeks. However, you should know that if you did owe rent prior to the fire, your landlord may deduct any rent you owed from your security deposit. Within those 3 weeks, your landlord must return your security deposit and also give you a detailed accounting of any money that was deducted from that security deposit. If your landlord refuses to return the rent or security deposit, you can sue in small claims court. LAFLA has a link in our presentation that will take you to the resources to help you be able to represent yourself in small claims court. If your home was fully destroyed, your landlord is not required to pay relocation assistance. And now this is the first time we are going to touch on your right to access disaster relief through the federal government. I'm going to say a couple of things repeatedly as we touch on this, just because it's that important. So in addition, to any state benefits that may come, you are eligible to help yourself to apply for disaster aid through FEMA. You're eligible for up to $43,600 in assistance, and this can recover lost vehicles, lost belongings, inside your home, furniture, electronics, that stuff. It can also be used to help you find new temporary housing. So please be aware you have access to those benefits. However, there are a few caveats, and this is what I'm going to mention a few times throughout this presentation. One, you may be denied if you have renter's insurance. So please go through your renter's insurance, find out, what you're going to be able to recover from them, and anything you have additional from that, you can apply to FEMA for assistance with. Second, FEMA does have the ability to uh, ask for repayment if benefits are duplicated. So for instance, if you got assistance for to replace a car from your renter's insurance, and you also got assistance for your car to replace a car from FEMA. FEMA can come back and ask for that money to be returned because the federal government prohibits duplication of benefits. So just be very cautious about that going forward. And also, if you go to disasterassistance.gov, FEMA has extensive FAQs about benefits and what you might be eligible for. Now, section is on tenants' rights in homes with minor damage. This means it's definitely repairable within a short amount of time, and there is the ability to return to the home. If your home was damaged but still safe for living, your tenancy is still valid and you still owe rent. But you should document any substandard conditions, any significant damages, and put those repair requests into your landlord in writing and keep that for your records. I always advise that email is the best way to keep in touch with the landlord because it keeps a very clear record. But I understand a lot of landlords prefer text messages. That's fine. Just make sure you are keeping those text messages for your records should you need them. The landlord is still obligated to maintain the safety and habitability of the unit. Um, you may be able to negotiate a rent reduction from your landlord if there's housing conditions or repairs that need to be made or that prohibit you from using the unit completely. If you withhold rent without an agreement, you do run the risk of getting an eviction notice. So do make sure you communicate that you're withholding rent in writing to your landlord and retain that writing for your records. Next slide, please. If you want to leave your unit, you do also have that option. You should provide notice of at least 30 days, or if you have a lease, the notice required by your lease if you want to end your tenancy. Under the lease, it may be 60 days. It may be 15 days. It all depends. So if you have a lease, consult that first. But without a lease, the minimum is going to be 30 days. If you want to leave in the middle of your lease, you should attempt, and you have a year-long or more lease, you should attempt to find a replacement tenant. If you leave within the middle of your lease and your lease does not allow for early termination, you may be responsible for the rent on the unit even after you move out until your landlord is able to get a tenant to replace you. Now, the landlord cannot prolong the effort, cannot take extra long, cannot refuse to look for a replacement tenant. So you do have some things you want to keep in mind there, but just be cautious and do always make sure you're communicating with your landlord in writing and retaining those writings for your records. And this section will cover tenants' rights in severely damaged homes. These are homes that will likely take a year or more to repair. There are roofs missing, significant fire or smoke damage, or homes to which the utilities have been significantly impacted, and water or gas service will not be returned to, or electricity service will not be returned to the property for a significant amount of time. If your home was severely damaged due to the wildfire disaster, including properties red tagged by the government. So, for instance, a home may look structurally sound. It may still be standing, but it may have had so much damage to the infrastructure or there's just too much smoke damage to be able to be remediated, and then the government might red tag it, which is basically declaring the property unsafe and needs to be completely or significantly repaired. Um, if that happens, you have two choices. You can choose to end the lease, and move to find other permanent housing. And in that case, you do not owe rent going into the future. And even if you did have a lease for a term, a year or more, it will end. Um, or you can reserve the right to return to your rental unit after repairs are made. That you will have to find temporary housing during that period, but you do have a right you could elect to have a right to return to repair after the unit is repaired. Just make sure you communicate what your decision is to your landlord in writing and keep records. And you should be communicating that decision as soon as you all are notified as to the final status of the condition of your home. If you decide to end your lease, as we mentioned before, your landlord must return your security deposit within 3 weeks. The unused portion of January's rent must also be returned pursuant to state law. If you were behind on rent but when the home was destroyed, however, the landlord can deduct the owed rent from the security deposit, like we said before. You should let your landlord know where to mail the check, or of course, you can make arrangements to go pick it up from them, whatever works for you. We understand that, obviously a mailing address might be a hurdle at these times. So, you can make those arrangements with your landlord. If your landlord refuses to return the rent or security deposit, again, you can and should sue in small claims court. And if you go to the link we've provided there, LAFLA has many resources to help you be able to represent yourself in small claims court. And small claims court is designed for individuals to be able to represent themselves. Next slide. If you do decide to return to your rental unit, your landlord is financially responsible for making the necessary repairs to return the home to safe and livable condition. Your landlord cannot ask you to contribute to those repairs. Your landlord cannot ask you to give your rental insurance money to help rebuild those repairs. Your landlord is responsible. Um, and again, you do have the right to return to the repaired home, but you will not owe rent while that home is uninhabitable. So, just to be clear, you will not owe rent if you do elect the right of return. However, once repairs are complete, you must resume paying rent. That is going to be your unit. You will have a commitment there. Next slide, please. And now we are going to cover the different protections offered by the rent stabilization ordinances that cover significant portions of the affected area. The first section we're going to cover is severely damaged homes in unincorporated LA County, which includes the area of Altadena. Okay, so our first section is that your unit is not covered by the LA County Rent Stabilization and Tenant Protection Ordinance. From here on, we will be using the abbreviation because it's quite a mouthful. So first, unfortunately, you are not eligible for relocation assistance for related expenses from your landlord. If your home was severely damaged, however, please save receipts for the related expenses, as you may be eligible for reimbursement through FEMA, like we mentioned, we discussed before, or other resources that come up. And please check disasterassistance.gov for more information on that. If you intend to return to your unit after it is repaired, notify your landlord in writing and keep records of that. Again, text message is fine. Email is best. Next slide, please. Okay. And this next is for relocation assistance that is available for units that are covered by the LA County Rent State RSTPO. We'll just do the abbreviation. So units that are covered by the RSTPO in unincorporated Los Angeles County do have some additional resources that you can access to help you rebuild. First, you may be eligible for temporary or permanent relocation assistance from your landlord, depending on your situation. Please check the LA County Department of Consumer and Business Affairs website for more information. There may be significant relocation assistance you can access to help stabilize you now that you've lost your home. And when there are also counselors available at DCBA to speak to you. Again, so now this is the more specific benefits. If your home was partially damaged and you're going to be displaced for 30 days or less, you are eligible for a per diem from your landlord for lodging, food, and incidentals. And again, this is from your landlord, so make these requests and put them in writing. If your landlord does relocate you to a hotel or a motel, the accommodations must still be safe and sanitary. The same habitability, regulations apply. And unless parties agree otherwise, it must be a reasonable distance from your damaged home. Now, given the large breadth of areas affected by these fires, may have to make some allowances there because there are so many people who have been displaced. Um, but you are eligible for these benefits through your landlords to help stabilize you while you're out of your home, because we understand these fires came suddenly out of nowhere at a really difficult time of year for a lot of people. So we want to make sure you know about these resources you have access to. Next slide. Now, if you're displaced from your home for 31 days or more, likely due to significantly more severe damage to your home, your landlord may need to provide you per diem for lodging, food, or incidentals, such as toiletries, or temporary accommodations that are comparable to the home you were displaced from. Again, please consult DCBA to see if your home and you qualify for these additional benefits. Um, and now we are covering how people who are covered under the City of Pasadena ordinance as and have severely damaged homes, the relocation benefits you may have. If your home is not subject to the Pasadena rent stabilization ordinance, unfortunately, you're not eligible for any rental assistance from your landlord. Again, you may be eligible for significant assistance from other sources such as FEMA, so please visit disasterassistance.gov. If you have questions as to whether your home is covered under the Pasadena Rent Stabilization Ordinance, please consult the Pasadena Rent Stabilization Board department so you can, and they will have information as to whether your home is covered. Um, Now, if you live in a home that is covered by the Pasadena Rent Stabilization Ordinance, um, and you are displaced for 30 days or more for necessary and substantial repairs, you may have three important rights. First, the right of first refusal of any comparable vacant unit owned by your landlord at the same or lower rent as you are paying when you were evacuated from your home. If you choose this option, you are not eligible for relocation assistance. The next right is the right to return to the unit, the same unit, at the same rent price. If you choose this option, you may also be eligible for relocation assistance. So again, that's three important rights. The right of first refusal of any comparable vacant unit owned by your landlord. So it's worth having a conversation with your landlord to see if they have any buildings in any other parts of the county or the city. Um, and or the right to return to that unit if you have a temporary place you can stay, or if you do not and you need the assistance, the relocation assistance may be available. Next slide, please. If you are eligible for relocation assistance, under the Pasadena Rent Stabilization Ordinance, the landlord must pay you 50% of the required relocation assistance according to their calculation of relocation assistance within 10 days of serving you with a notice of termination of tenancy to make repairs. So you're I know that was a lot. So if your home has been severely, significantly damaged and your landlord is issuing you notice of termination of tenancy to let you know that they need to make these significant repairs within 10 days of serving you with that notice, the landlord must pay 50% of the required relocation assistance. Um, then if the landlord must pay the remainder either into an escrow account that pays you the remaining relocation assistance at least 28 days prior to the expiration of the notice of termination of tenancy. So that's one. Or if the landlord does not want to place funds in an escrow account, the funds must be paid directly to you upon confirmation that you vacated the unit. So That was a lot. Again, the landlord must pay you 50% of the required relocation assistance within 10 days of serving you with a notice of termination of tenancy. And the termination of tenancy must be based off their need to make repairs. And then the landlord has two options to pay the remaining 50%. Can pay it into an escrow account that pays it out to you at least 28 days before the expiration of the notice of termination of tenancy, or the landlord can pay it to you upon confirmation that you are vacating the unit. Next slide, please. And now we're going to cover the additional relocation benefits and rights available to tenants in severely damaged homes in the city of Los Angeles. If your home is in the city of Los Angeles and you are not protected by rent stabilization or just cause protections, your landlord does not have to pay you rent relocation assistance. If your home was severely damaged, though, again, please save those receipts for any expenses you've incurred since being displaced, for lodging, for food, for toiletries, for clothes. You may be eligible for, again, for reimbursement through FEMA or other resources. If you intend to return to your home after it is repaired, again, notify your landlord in writing and keep those records. Next slide. Now, if your home is a rent stabilized unit or subject to the just cause ordinance in the city of LA and partially damaged, your landlord may not owe you relocation assistance now. However, depending on what is done with the property, your landlord may owe it later if you are displaced. Your tenancy is protected and you have the right of return to your unit. So you will not lose your rent stabilized unit if you elect the right to return to your unit. Next slide. Now, depending on what your landlord does with the property, if it needs to be demolished or repaired, as long as it was not destroyed in the fire, you may be entitled to certain relocation benefits. One, permanent relocation if the unit is demolished or converted. Two, temporary or permanent relocation if the unit is repaired. Um, Now, if you are in a rent stabilized unit and only, this does not apply to just cause, and displaced for 30 days or less, you may be also eligible for a per diem for lodging, food, and incidentals from your landlord. So let's review that really quickly. Um, if your unit was demolished or converted, as long as it was not destroyed in the fire, you may be eligible for permanent relocation funds from your landlord to help you find a new home. Um, Now, if your unit is repaired, you may be eligible for temporary or permanent relocation. If you are in a rent stabilized unit and displaced for 30 days or less, you may also be eligible for a per diem. And the city will be reviewing this on a status of any specific building on case-by-case basis. Next slide, please. And now this is where we're going to cover new disaster-related tenant protections. Right now, the most current one we have is from the state. Next slide, please. Governor Newsom issued an order prohibiting evictions based on tenants allowing displaced fire victims to live with you, even if your lease prohibits additional tenants. I should say that this is a fairly narrow protection. It only protects tenants who are being evicted based on having unauthorized occupants, aka people living with them outside of the parameters of their lease, who are also displaced victims of the wildfires. So it only protects from evictions for that specific reason. And this order is in effect until March 8th, 2025. Next slide, please. And also, there's additional price gouging protections that are in effect, and these are in effect through next year, most of them. Next slide. Um, CA Penal Code 396 protects consumers against price gouging during times of emergency, including natural disasters, and has been extended through January 7th, 2026. These price gouging protections protect all rental housing, all hotel accommodations, repair costs, and other essential goods and services like food, gasoline, hygiene items, all of that. It prohibits a price increase of more than 10% of higher than pre-disaster rates. If you see stores or hotels inflating prices beyond that, you should be reporting all of this immediately to the state AG's office, which will provide information later. Um, this applies to current and prospective tenants. So again, this is prohibited in rental housing. If you are seeing, rental units that you are looking at suddenly jump in price, we are absolutely, it absolutely needs to be reported. And same with current tenants. If you are seeing sudden rent increases, um, outside of, if you are in a non-rate stabilized area, if you're seeing sudden rent increases of more than 10%, absolutely you should be reporting this. And it also prohibits evictions of tenants to lease to another tenant for higher rent. If this is happening, this is a defense in an eviction case. So you should keep note of that if you do see your unit being posted for rent at a significantly higher rate. Next slide, please. Mhm. Okay, for those who are protected by rent stabilization ordinances, landlords must also adhere to any rent stabilization ordinance that applies in your area. So if your rent stabilization ordinance limits rent increases at, let's say, 8.8%, then that is all that your rent can be raised, only within what is allowed by your rent stabilization ordinance. Um, Landlords cannot raise rent over the allowable RSO limits, which are currently in the City of Los Angeles. Rent increases are capped at 4%. In unincorporated Los Angeles County rent stabilization ordinance, the increases are capped at 2.565% to 3.565%, based on how many properties your landlord owes. And under the Pasadena rent stabilization ordinance, increases are capped at 3%. If a rent stabilization ordinance does not apply to your area, your landlord must adhere to the anti-price gouging statute. So 10% is the absolute limit because that is the absolute ceiling on the anti-price gouging statute. Next slide, please. To report price gouging, if you're in the city of Los Angeles, please call 311 to report and please relay as much information as possible. If you're in Los Angeles County, please report any price gouging you see in the housing or consumer market to DCBA, the Department of Consumer and Business Affairs, and we have linked both their website and their phone number. Their phone number is 800-593-8222. You can also report this to the California Attorney General at oag.ca.gov or at 800-952-5225. Again, violators, and price gouging is a criminal offense, and violators are subject to criminal prosecution and civil fines. So please, if you see this, report it. Thank you. Next slide. And also, the existing protections against tenant harassment are still in effect. We know what's happening out there, so we want to make sure you know your rights so you can protect yourself against this from your landlords, and you can know how to access the help you need to protect yourself. Next slide, please. If you live in the city of Los Angeles, you are protected from the Tenant Anti-Harassment Ordinance, otherwise known as TAHO. If you live in a rent stabilized unit in unincorporated Los Angeles, you are protected from landlord harassment by the rent stabilization ordinance. Pasadena renters are also protected from tenant harassment, retaliation, and discrimination. We have linked sites from the City of LA, from Unincorporated Los Angeles, and Pasadena, so you can get more information on the protections and how to contact the cities or the county to help you defend yourself. You're protected from a broad range of harassing actions. That includes refusing to make repairs, yelling at you in your unit, um, uh, stopping by your unit unannounced, trying to enter your unit unannounced, threatening you, suddenly changing the terms of your tenancy. All of these count as harassment and even more. So please consult these websites, and you will be able to see the full range of behavior that it counts as harassment, and you should absolutely report it. And it also is a defense to eviction in many cases. So please make sure you know your rights to fight back against tenant harassment. Next slide, please. If again, we covered some of this. If your landlord stops making repairs, tries to change the terms of your tenancy, suddenly refuses rent, reports activity to a government entity, or threatens to report activity to a government entity, starts asking about your citizenship status. All of this counts as tenant harassment. If you're in the city of Los Angeles, reported to this Los Angeles Housing Department, LAHD, at 866-557-7368. It's really important that this behavior gets reported so it does not compound. And again, we might see an uptick in this due to the sudden influx of new tenants looking for places. So please, be on the lookout for this. Unincorporated county tenants also should contact the Los Angeles County Department of Consumer Business Affairs at 800 593-8222. And Pasadena city tenants should go to the rent stabilization page at the City of Pasadena website to contact a housing counselor who can assist you with this. Next. And now we're going to cover some commonly asked questions about tenants' rights post the wildfire disaster. Question 1. If I vacated my home on January 7th or 8th and am not able to return, does my landlord have to return the remainder of my January rent payment? Yes. Your landlord under state law must return the unused portion of your January rent payment if you are permanently displaced or temporarily displaced through the end of January. You do not have to pay rents for the days you are unable to access or safely live in your unit. Make sure you communicate your request for the return of your January rent payment in writing, and you can also include your security deposit in that, and keep the records for your writing keep the writing for your records. If your landlord refuses to return your rent or security deposit, again, LAFLA has resources to help you represent yourself in small claims court to demand your money back from your landlord. Next slide, please. Can my landlord require me or my renter's insurance to cover repair costs for the unit? Absolutely not. Your landlord cannot hold you financially responsible for the repairs. This includes if this occurs and you are in the city of LA, contact the LA Housing Department. If you are in unincorporated Los Angeles, contact the LA County Department of Consumer and Business Affairs. Pasadena residents should contact the Pasadena Code Compliant Division. Your landlord is wholly responsible for all repairs to the building and individual units. If your landlord is demanding that you financially participate, again, please report it to the relevant Housing Bureau agency. Additionally, if you never mind. Next slide, please. Question 3, how do I know my home is safe? This is a very good question. So first, local governments are required to inspect after major repairs. Landlords are required to obtain permits from the municipality to make repairs, and then once before those permits can be signed off on, an inspector from the municipality has to come out and clear those. But if you do feel like your home isn't safe after repairs, please contact your local housing department for additional inspections. Now, if your landlord refuses to make necessary repairs, absolutely please document your requests, but also you can make a complaint with your local housing department. Or, under the warranty of habitability, you also have the right to make the repairs yourself and deduct or withhold rent to compensate yourself for those repairs. However, these actions may result in an eviction lawsuit against you. So it is really important for you to retain the communications with your landlord where you attempted to get them to make the repairs and then you notified them that you were going to make the repairs. It's really important for you to communicate that in writing and keep those writings for your records because that will serve as a defense against you if your landlord tries to evict you for repairing and deducting or withholding your rent to compensate yourself for those repairs. And you may also sue your landlord. Again, you want to keep detailed records, but you can, depending on the amount you spend on these repairs, you may be able to also recover from your landlord in small claims court. Next slide, please. Question 4. Will my insurance company pay for damaged belongings? If you have renter's insurance, your damaged or destroyed personal belongings are may be covered. They're likely covered. That is what renter's insurance is supposed to cover. It's supposed to cover the belongings inside of your unit. You should reach out to your insurance company immediately to determine the next steps and file your claim as soon as possible. If you need help working with your insurance company, or you've been approached by somebody that you suspect is uh, uh, as a spec offering a scam, or you just want to you need help getting in contact with your company, please contact the California Department of Insurance at 1-800-927-HELP. Or you can go to www.insurance.ca.gov. Uh, the Department of Insurance, as you know, has issued many edicts post wildfire, directing insurance companies to work equitably with their insurees. So please contact the California Department of Insurance if you find yourself having trouble working with your rental insurance company. Next slide, please. Question number 5. Do I qualify for FEMA assistance or other aid? Yes. As a renter, you are absolutely eligible for disaster assistance from FEMA to help you find temporary housing, to help recover your any belongings you may have lost, including cars, clothes, all of that. However, if you are insured, you must provide information from your insurance so that and FEMA will deduct the amount you are awarded from them based on your insurance payout. Um, Another thing to keep in mind is that for renters, sometimes your landlords on their FEMA applications may claim your belongings, such as your car, or if you are living in a more if you are renting a room or you are renting another space from your landlord that is you maybe don't have a formal agreement, you should be aware that sometimes landlords will claim your property as theirs for their on their FEMA application. When that happens, please reach out for help. We are gathering resources and information to help renters for when this happens. But first, start with getting your application in at www.disasterassistance.gov or by calling 1-800-621-3362 or by visiting a disaster recovery center. There is one on the east side in Pasadena, and there is one on the west side serving the Palisades area. And you can do your applications in person at a disaster recovery center. Um, If you are not insured, you may also qualify for disaster loans to help you recover from the U.S. Small Business Administration. You can apply there at www.sba.gov. The site services multiple languages, and same with FEMA. You have the right to apply and communicate with somebody in the language you feel most comfortable with. And if that is not happening, um, uh, please contact us. Uh, 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 please reach out to the California Attorney General because that would be discriminatory. So we want to make sure everybody's able to access these resources in the language that they are most comfortable in. Next question, please. Question 6. Can my landlord raise my rent right now? Well, this is a complicated one. It depends on when your last increase was and what protections your housing falls under. So, for instance, if your home is subject to a rent stabilization ordinance or the State Tenant Protection Act, your landlord must follow all existing housing laws and the anti-price gouging statute. If your landlord tries to evict you after suddenly raising your rent, please contact Stay Housed LA immediately, www.stayhousedla.org, and so we can try to match you with an attorney to help you navigate the eviction. But again, make sure you understand what protections apply to your housing. If your home is subject to a rent stabilization ordinance or the Tenant Protection Act, there is a limit on how much your landlord can increase your rent. Next slide, please. Question 7. What happens if I lost my rent stabilized unit? Well, I'm very sorry. Unfortunately, your rent stabilization status will not apply to your new temporary or future permanent housing. The rent stabilized or tenants that were living in a rent stabilized unit may have a right of return to repair or rebuilt units, in which case you would still have your rent stabilization status with that unit. But if you leave that unit permanently, you do not get to carry that over to your next unit. I'm very sorry. Next slide, please. Question 8. What happens if I had a Section 8 voucher and my home was destroyed or severely damaged? If you had a Section 8 voucher and your home was destroyed or severely damaged, contact your Section 8 Housing Choice Voucher caseworker immediately, and a new moving voucher will be issued to you so you can start looking to obtain new housing. Next slide, please. Question 9. Can my landlord evict me because they or their family members want to move into the unit? In some cases, landlords can evict tenants if they do want to occupy the units themselves or allow members of their family to move in. That is an exception to under many just cause protection ordinances. If your landlord does try to evict you for this reason, though, contact Stay Housed in LA immediately at www.stayhousedla.org. There are requirements that go along with this that your landlord must fulfill, or you may have a right to stay in the unit. If they don't, you may have a right to stay in the unit. So please contact stayhousedla.org immediately. Next slide, please. Question 10. Can I be denied housing or emergency shelter because of my personal identity? No. You are still protected by all federal, state, and local anti-discrimination laws in all emergency shelters, hotels, motels, temporary housing, or short-term housing. If you feel that you've been discriminated against due to race, gender, age, sexual identity, disability, family status, having children, source of income, religion, or especially immigration status, please contact the California Attorney General at oag.ca.gov or at 1-800-952-5225. And just as a reminder, you cannot be asked about your immigration status in order to access an emergency shelter. Next slide, please. This is the end of our presentation. Thank you very much for listening. We hope this was informative. For more tenant resources, please visit stayhousela.org or call us at 1-888-694-0040. Below, we've listed the Stay Housed LA legal organizations servicing the affected areas. In Altadena, Pasadena, your legal services organization is Neighborhood Legal Services, and they can be reached at 1-800-433-6251. For the Pacific Palisades and Santa Monica neighborhoods, we here at Legal Aid Foundation of Los Angeles are your legal aid is your legal aid organization that services your area. You can reach us at 800-399-4529. If you're in the city of Los Angeles, you can also contact us here at Legal Aid Foundation of Los Angeles at or you can also contact Inner City Law Center. Inner City Law Center's phone number is 213-891-2880. Thank you very much for your time. And our thoughts are with everybody who is affected by these wildfires.